Hi, this is Andre Schoenweisner, and welcome to video number 2. Here we're going to explain a little bit more about what's included in these books and why you need them. Now, you've watched video number 1, which was particular to the type of work that you're doing right now. And it explained a little bit as to how your particular profession makes this profession an easier secondary job or additional service that you can provide to your existing clientele. If not, please watch video number 1 again. In this video, we're going to go a little bit more in depth as to what things you can do. So let me start by talking about how to collect or enforce these judgments. We prefer to use the word enforce or enforcement versus collection. Collection is more of a thing that you do prior to receiving a judgment from the court. Enforcing is what we do. We are enforcing the court order. You collect before you go to court. You enforce after the fact. Okay? So, what type of things can we do? Well, this book, How to Collect When You Win a Lawsuit in California, gives you 19 different ways of collecting the money. Okay, so let me go over just a quick list of some of the things that's included. The book will show you how to place a lien on real estate, how to place a lien on business property, how to negotiate voluntary payments, how to conduct a debtor's exam, and we'll talk a little. Well, let's talk about it now. You have a debtor. You found out where he lives, but you have no idea as to where he works, where he banks, what kind of car he owns, whether he's got a loan against the car, and so forth. Okay? So one of the things that you can do is you can do a debtor's exam. And that's where you have them come into court and you can ask them all kinds of questions about where their assets are, where their income comes from, and so forth. Okay? So the book gives you the forms on how to do it and how to serve them and when to serve them and so forth. My particular suggestion and what I do is that I assume anyone coming into court is going to lie to me. I assume that. They're going to come into court and say, I don't have a job, I'm living with my mom, I don't have a car, I don't have a bank account, I don't own anything. And unfortunately, unless you can prove otherwise, there's nothing that the court can do. They can lie to you. So what is it that you can do? What takes you to the next step? Well, I, for one, like to subpoena third parties, meaning other people other than just the debtor, to get the information from them. So, for example, if I find that my debtor is renting somewhere, I subpoena the existing landlord or management company in order to get a copy of their application, to get a copy of their checks that they've been paying the rent with, for example. Okay? If I find out that they just bought a car and it's got the license plate shows that they bought it from, I don't know, Toyota of XYZ. Okay? Well, then I go ahead and I subpoena Toyota of XYZ. I want to see a copy of their loan application. I want to see a copy of their deposit check. The down payment check, not deposit. Down payment check, okay? If I know who financed the car, I want to go ahead and subpoena them. I want to get their loan application. I want to get copies of the last 6 ways that they've made the payment, whether it was by check or by wire or by credit card, etc. Okay? If I know where they work, I want to subpoena them. Is it a direct deposit, for example? I want to know where the direct deposit is being deposited at, because that'll tell me where they bank. Okay? So different things that they have or that I know that they have will possibly get me something else. One of the things that you can do once you have a judgment is you can run their credit report. Their credit report may not show you who they owe, but it may show you who they've applied for a loan with. For instance, they've applied for a car loan, and it's through one of the smaller companies or one of the companies that's not a dealer company. In other words, it's not Toyota or Nissan or Ford. It's a third-party company. Well, that usually tells you that the credit's not that great. They couldn't get financing through the dealer. So they went through their credit union or through a third party that does harder type loans. Well, I want to subpoena them to get a copy of the loan application. The loan application, maybe they're lying on the loan application, but at least it gives me somewhere to go to find out where they're banking or where they're working and so forth. Okay, so that's in the book. They just transferred something. They owned a piece of property and they transferred it to their sister, for example. Okay, well, that may give me a chance to go after them for a fraudulent transfer case. Okay, where do I seize? How do I seize their wages if they're working? How do I seize their bank accounts or safe deposit boxes? What if they own a business? Can I get the money that's in the cash register? Can I take the assets of the business? For example, they own a clothing store. Can I take the clothing? Can I take their cash register, their chairs and tables and desks and computers and stuff like that? What if they have something in their home and I know about it? For example, they own a painting that's worth several $1,000s or maybe more. Can I go ahead and have the sheriff take it? Can I go ahead and if it's somewhere, if the property is somewhere that I can't grab it or have the sheriff take it, can I force them to come into court and have the court order them to give that property to the sheriff so the sheriff can sell it? Okay, those are all different ways of collecting money from a judgment. And the book will take you step by step on how to do it. Okay, so you can collect, you can seize and take their business assets. You can take their vehicles. You can take personal assets. You can go into their home and take items. You can ask the court to order them to deliver property to you. For example, they took money, and you can prove that they've taken money and deposited in a bank in a different state. Well, a court order from California is not going to get to it unless the bank has a branch here. But you can have the court order them to bring the money back. Okay? What if there's a third party that's making payments to them? I don't know, they're in a band that they've had published some songs, and they're getting royalties from it. Can you go after that? Sure. They own rental property and they're getting paid rent by their tenants. Can you go ahead and force the tenants to pay you instead of paying them? Yes, you can. Okay. So the book will take you through approximately 19 different ways of collecting the money. And obviously, some of them work for more than one thing. So therefore, you can use your imagination, but it'll get you started. Okay. The book also tells you what to avoid. There are laws that protect debtors. You cannot call them at 12 o'clock at night every night and every half an hour thereafter, basically bothering them and trying to intimidate them into paying you. You can't do that. You can't call their employers or talk to their neighbors and basically tell them, hey, this guy's a deadbeat, he owes me a lot of money, and make them look bad. What's going to wind up happening is they're going to turn around and sue you, and then you'll wind up owing them money instead of the other way around. So there are particular things that you cannot do, and you need to read the book in order to know what not to do. Now, could you do the research on your own through Googling and so forth? Yes. If you have that much time on your hands, and you want to go ahead and go looking for information that's all in one place and easy to read, you can do that. I would not recommend it because if you miss something, you could wind up in trouble and owe people a lot of money. Okay? How do you communicate with the debtor or other people? How do you get information about the debtor? Placing liens, like I said, on real estate, on business assets, on personal property. How can you possibly get the debtor to pay you voluntarily? You know, a lot of times what we do is we try to show the debtor that we can do something, even when it's not going to get us really everything we want or even a lot of it. But it just lets them know we're here, we're not going away anywhere, and we can make your life difficult by doing what we can legally do, which is take things. At that point, let's say, for example, I hit somebody's bank account And it was only $300-400 at the time I hit him. But guess what? The bank charged them another $100-150 because of my lien. So now they're out, whatever, $400-500, and now they know I can find their bank account and I can take their money. So the question is, are they going to sit back and wait for me to do it again? Or are they going to go ahead and negotiate with me a voluntary payment plan that as long as they keep making the payments, I will not go ahead and levy on their bank account again, right? Many times, especially with debtors that have a good job and have money, they will want to voluntarily make an agreement and they will abide by it in order not to be surprised. Okay? So that's something else the book talks about. Determining what the debtor owns. Now, if you're a private investigator or a process server, maybe you already have the ways of getting to finding out where the assets are. If you're not one of these professions and this is new to you, the second book on the success as a judgment recovery specialist, it tells you all the different databases you can belong to, which are some are free, some are pay. But worst case scenario, if you don't want to go into a monthly expense, especially at the beginning, you join up with someone who can get the information. For instance, a private investigator. Maybe you find one of those and you set up a business account where they give you a small discount because you're going to do it more often. You're not a one-time client. And you let them do what they're good at, and then you do the rest. Okay. Now, whether you collect that money up front from the judgment creditor, and by the way, the judgment creditor is the person that won the case in court, or whether you pay that money up front and then you recover it later, that's up to you and it's up to your contract. So you'll want to read that book to figure out how you're going to set up your contract, what it's going to mean, what you want included, what you don't, and what's going to be included, what isn't. It's also going to depend on how much money you want to spend. Are you willing to spend a little bit more money up front because you're going to get a lot more on the back end? Or do you want to require that the person giving you the judgment pays for some of the expenses up front, but in exchange maybe you'll give them a bigger percentage of what you collect, So that's all negotiable, and that's something that you should look at and determine which way you're going to go. If you're going after somebody's bank account, or you're going after their wages, or you're going after their car or their real estate or whatever, what do you need? Well, you need a memo of costs and you need a writ of execution. Well, what county do you get it from? What information is going to be included? Are you going to need a separate motion to take the item or not? For example, if it's somebody's home, you're going after somebody's home, they've got a lot of equity. Even if they have a lot of equity, besides getting the writ of execution and having the sheriff start the sale, you will have to go into court with a motion asking the court to order the sale. Why? Because it will be up to the court to determine whether the home, and by the way, let's make it a little bit more difficult. The debtor owns a piece of real estate that is rented. You know he's renting it out. Can you take it without a motion from the court? I would say no, because it is up to the court to determine whether the property is owner-occupied or non-occupied. And it is up to the court to determine whether the property is homesteaded or not. So you will have to go into court and do a lot of other stuff. And going after real estate, by the way, is one of the more expensive things that we do. So it has to be a much bigger judgment. Okay? So the book goes into that. How to enforce against deposit accounts, how to collect on wages. What if somebody else owes money to the debtor? Can you go after that? Well, the answer is yes. But you're going to have to be able to show that the person owes the money to the debtor. And you're going to have to get a court order telling the debtor of your debtor, in other words, the third-party debtor, that instead of paying the guy he owes, he should be paying you because the guy he owes you money. Okay? So that's going to take an extra step. Can you collect from a business that's existing? So in other words, they have a store, they have a donut shop, or they have a mortgage company, or they have a plumbing supply store, or anything like that. Can you collect against them? Can you take their stuff? Well, it depends on who owns the business. Do they own the business, or does their corporation own the business? Okay? And if their corporation owns the business, does that mean it's over with? Or can you go after the shares, the ownership of the corporation? A corporation is a separate entity. It's owned by shares. Well, if your debtor owns the shares of the corporation, can you go after those shares and now you become the owner of that business? Yes, you can. Go after a car. Can you go after what's it going to cost? Everything we go after has an exemption amount. In other words, there's a certain dollar amount that is exempt from you taking it. Okay? And it's the same when somebody goes bankrupt. There are exemptions. And what does that mean? That means that before I can take the asset, or before I can have, or when I have the sheriff sell the asset, the first X amount of dollars goes to my debtor. That was exempt money. He's going to get that. I get anything over and above that. So, if, for example, I'm going after a car that's worth $3,000, and the exemption on the car is $2,000, and it's going to cost me $2,000 to pay the sheriff to go take the car, do I want that car? The answer is no. It's going to cost me $2,000, and the first $2,000 goes to him, so that's $4,000, and the car's only worth $3,000. That's not something I want to go after. Okay, I want to go after something that has a lot more equity in it. Okay, can I go after tangible assets? Okay, or intangible assets? Yes. Can I go after real estate? Yes. You go after something, and the debtor files what's called a claim of exemption. Now, a claim of exemption is basically a motion, a document that he gives the sheriff that says, I believe that this item is exempt by law, and therefore you cannot take it. Well, what happens next? Well, what happens next is that it's up to you to oppose the claim of exemption, and you're going to have to file for a motion. How do you do that? How do you figure out whether the item is really exempt or not? What are the dollar amounts? How do you prepare that motion, and what do you do? It's right here, chapter 15. It gives you the forms, it tells you how to do it, and the forms that are needed. Okay? Can you recover costs and interest associated with the judgment? Well, the interest, if it's a regular case in California, meaning small claims or civil, is 10% a year. That's by law. But other judgments have different interests. For instance, a federal case may have a different interest. A family court case may have a different interest. So you have to figure that out. Can you collect it? Yes, but you have to request it and you have to report it, especially the costs. The interest is statutory, but you still have to update the court. So that's on chapter 16, for example. What happens if your debtor files for bankruptcy? Can you still go ahead and keep collecting? You were going after a bank. You took $10,000 out of the account. It's at the sheriff's, or it's at the bank, and they're getting ready to send the check to the sheriff's office. And all of a sudden, you get in the mail a notice that they have filed for bankruptcy. What do you have to do? And what happens if you don't do it? Well, I'll tell you what happens if you don't do the right thing. The court can sanction you thousands and thousands of dollars to pay for the other side's legal fees to stop you from doing what you should have known not to do. That's called a sanction. And that can cost you a ton of money. So you want to read about this stuff before it happens. If you get a notice of bankruptcy, that they have filed for bankruptcy, you want to stop, you want to read what you're supposed to do, and you want to take the right actions. Okay? If not, it could wind up costing you a ton of money, and you'll have to return the money that you took, or the property that you took. Okay? What happens if the debtor dies? So somebody owes you money, and it hasn't been collected in 5 years, and by the time you start working on it, the person has passed away. Does that mean that the debt's gone? Or can you go after his assets or his family? Well, that's all going to depend on the judgment. It's all going to depend on his assets, right? And it's all going to depend on how soon you move to protect those assets and to protect your rights, okay? So that's on chapter 18, for example. Okay. You want to go after a business, for example, and you want to file a motion with the court to allow you to go after those assets in the court. Well, the minute that you serve that other party, your debtor, with the document that says, I'm going to have a motion to take this, what's going to happen? That item is going to disappear. They're going to move it. They're going to move it to their sister's house. They're going to put it in somebody else's name, etc. So you're probably going to want to file some kind of protective order. And you're going to probably want to do that without them being there, without them knowing that that's what you're doing. Chapter 19 gives you all the documents in order to do that. Are you ready to renew your judgment? You know, interest is calculated at 10% a year of the judgment amount. Okay, so I have a judgment for $10,000. That means I'm getting $1,000 worth of interest every calendar year, right? It's what's called simple interest. Well, it's been 5 years or so. Is there any way for me to collect more money? Well, yes, there is. If you renew the judgment, the interest from that point on is calculated at the renewed amount, which means that the principal plus the interest up to that date. So if you renew it after 5 years and you had a $10,000 judgment, now your judgment is for $15,000, and any further interest is 10% of the $15,000 instead of 10% of the $10,000. So now for that time being, you are now getting compounded interest because it's not only on the principal, but it's also on the interest. That is on chapter 20. How do you serve the papers on the debtor? What is the correct way of doing it? That's chapter 21. And then what do you have to do when you get paid off? Are there any other steps that you have to take by law once you get paid off? And what happens if you don't? Again, if you do the wrong thing, that could cost you a ton of money. So you want to make sure you do the right thing. Okay? So all of that information and more, and samples of it and so forth, are in this book. Now, one of the things, and you may recognize the title, by the way, and if you Google the title, you'll find several books with the same title. There are different versions from different years. This book is the version from 2016, so that is the brand new version. There are previous versions from the years 2003 and 2005. Now, laws change every single year. So why anyone would use an old book that has old laws and old exemptions and old dollar amounts and so forth, I've got no clue. To me, it's crazy, but people do it. But one of the major differences here between the new book and the old book is how we did the examples and the samples. The book has got tons of examples. Every single chapter shows you an example as to what happens and what can be done and so forth. The old book would have a different name for the creditor, that's the person that's owed the money, and the debtor, that's the person that owes the money. So they would have a different name for each one of them in each different example. So you'd be reading the example, and three paragraphs down, you'd be trying, wait a minute, is Mary the person that's owed the money, or is Mary the person that owes the money on this one? And you'd have to go back and read it. To me, that sounded silly to do. So every example and every sample uses the same people. In every example and in every form, you, the creditor, will be Amy Wright. You live on my street in my town, California. The person that owes the money, which we call the bad guy, and by the way, not everyone that owes money is the bad person. Something may have happened in their lives, an accident, some unforeseen debt, a loss of a job, etc. Maybe they're not bad guys, but for our purposes, we're going to call them the bad guys. And so in every example and every sample, that's going to be Jeff is bad. And he lives on Crappy Street in Helltown, California. So as you're going through the samples and the examples, when you see Jeff is bad and he lives on Crappy Street in Helltown, I'm pretty sure you're going to recognize that that's the person that owes the money. And Amy Wright, who lives on my street in my town, is the person that's owed the money. So it's going to be very simple to follow it through and through. The other thing that the book will do for you, as we spoke about previously, is that it's telling you which codes, which laws, allow you to do different things. So that when you do it, if you wind up having to go in front of a judge, which is not that often, and the judge isn't familiar with what you're doing, and he questions it, you'll be able to tell him which laws, which codes allow you to do it. And he's not going to take your word for it. Okay? He's going to go take the laws, look up what you're telling him is the reason you can do it, and then he's going to confirm that you're correct, and he's going to rule, hopefully, in your favor. Now, judges have a lot of leeway in what they can and can't do, and every situation is different. So the fact that a law says you can do something doesn't, unfortunately, always mean that you'll be allowed to do it. But at least you'll have a good groundwork as to why you're doing it, what allows you to do it, and hopefully that'll be fine. Okay? So that's what this book will do for you as far as moving you forward in this business. And maybe you're doing this for yourself. When I first started, I had a business that resold credit reports to mortgage companies and car dealers and so forth. And they wouldn't pay me, and so I wound up having to take them to court, get lawsuits against them, and I had to try to collect. And when I decided to change careers, I realized that I enjoyed being in front of a judge. I enjoyed being in court. I enjoyed the chase of trying to find someone that's hiding from me. And that's why I decided to do this, and I've been doing it since 2007. The second book that we were talking about, Success as a Judgment Recovery Specialist, and you may not be able to see it great on the video, but you can go online and see it. And again, you can get both of these chapters. You can get the table of contents and chapter 1 of each one of them for absolutely free. All you have to do is give us your email address, and then you can see it and download it and so forth, and you'll see exactly what's missing. So what the book tells you is that 80% of judgments go unsatisfied, in other words, uncollected. So there's a lot of business out there. The thing is that you have to decide and realize which ones you want, which one's going to be easier to collect or even possible to collect, and which ones are dogs. In other words, they're not collectible. Okay? If a person lost their job, still isn't working, is living at their mom's house, and is driving a 1982 Pontiac Le Mans, and I'm not sure that the car was available on that year, so I'm just using an example, that person is not someone you can collect on at this time. Are they going to be judgment proof for the rest of their lives? No. It may be something where you take the judgment and you keep renewing it until their situation gets better. But for the time being, you need to realize who is collectible and who isn't. Okay? How should I set up my business? Should it be a corporation? Should it be a DBA? Well, it depends on how you're going to do business. Are you an attorney? In which case a corporation might be fine. Are you not an attorney? You may prefer to go as a DBA. Okay? And there's different reasons for it. How do you locate the judgments? You know, when I first started, I went down to the courthouse, looked at the files, decided which judgments I wanted, took down the information, then I did some research, found the creditor. Again, the creditor is the person that's owed the money. And I contacted them. Well, how do you contact them? Are you going to send them a letter, a postcard, make a phone call? How exactly are you going to reach them, and what are you going to say to them to try to get that judgment if you don't already have it? And how much should you pay for it? Are you going to pay for money up front and therefore buy the judgment as a whole? Or are you going to buy it on a kind of a consignment situation where you are buying it for nothing right now, but with the promise that once you collect the money, you will pay them X percentage of what you collect? And how will that work? So you need to prepare a acknowledgement of assignment. That is where you tell the court that you are taking over this judgment, and it's signed and notarized by the party that owned the judgment before. And you're going to need a contract. And the contract's basically going to spell out how exactly you're buying this judgment and how exactly the money's going to be split later on. Okay? And what if the person that you're buying the judgment from used an attorney when they went to court? Does the attorney have to get involved? Do they have to sign anything? That's something you're going to want to look at into this book to figure out, okay? Because it's really going to depend on several factors, okay? So what kind of judgments? Me personally, if I'm just starting out, if I have judgments already, then I'm going to take those, obviously. For instance, I'm a property manager, and the judgments are there. All I have to do is ask for them. I'm going to take them, obviously. But let's say I don't have any judgments. Where do I want to start? Do I want to start with that $3 million judgment against a guy that is a convicted fraudster and con man? Or do I want to start with that $3,000 judgment from one neighbor to the next because of some kind of problem they had with their dog or with the fence or so forth? Okay? I want to build up my experience, me personally. I want to build up my experience and my know-how and my comfort level being in front of a judge with the small ones. Because, number one, no one's going to spend $60,000 hiring an attorney to fight you when you're just going after $3,000 judgment. If you're going after $3 million, they may spend $100,000 hiring a high-priced attorney to fight you every step of the way. So think about that kind of stuff, okay? What are you looking for when you look in the case at the court? What are you looking for? What are you reading? What does it mean? Unless you're a paralegal and you already know what's in a court file, this book will show you and explain to you what you're looking in the case file. What words are you looking for? What does it mean, each thing? And does that in itself disqualify the judgment from being something that you're interested in or not? The other questions are, for example, when do you do your research? Do you do your research before you get the judgment or after? Me personally, I always prefer having the judgment, then doing the research, and then if I don't like it, I can always return the judgment to the person that gave it to me. Okay? But again, different people in this industry do it different ways. So therefore, you have to figure out what's comfortable for you, what's going to work for you. You want to read up on different strategies, and that's what this book gives you, and that's what the forum that they provide gives you. Okay? So those are things that you want to look at. It tells you 5 different ways to get even more assignments and spin-off businesses, because in every business, you should be looking at what else can I do with what I'm doing right now? How else can I make money? It is much easier to sell shoelaces to someone if you're already selling them shoes. And therefore now, you got them in the door to sell them shoes. Now you can sell them shoelaces. Maybe you can sell them socks. Maybe you can sell them t-shirts, etc. That's what stores do. And that's why they sometimes have these incredible prices on one item. It's to get you in because that will hopefully allow them to sell you something else. Same thing with this business, same thing with your business. You should be looking at what else can I do with the marketing that I'm already doing in order to make as much money as possible or to maximize my potential and my opportunities. Okay? So, should you start a corporation? Do you need a business license? Do you need a private mailbox? One of the things I see for people, and by the way, this is people with experience, is that they'll have an email address that has nothing to do with their business. Well, if I'm in business, one of the biggest marketing tools I have is a website for that business and an email that goes along with that website. Okay, so for example, my website for this business is afjudgment.com. It's got the word judgment in it. So someone Googling for judgment recovery is going to come up with my website. When I send out emails to people, it comes from Andre@afjudgment.com. So every time I send an email, It is a marketing tool. It is letting people know what it is I do for a living. Even if I'm emailing somebody for something else, completely different. They at least know, oh, he has a website, and this is what he does for a living. And who knows, maybe their sister, their brother-in-law, one of their friends, they may have a judgment, and now they'll refer them to you because they know who you are. So if you're in this business, or if you're not in this business, you might want to consider getting a website for it. If you decide you want a website, go to our website, quicknopublishing.com, and go down and take a look at the link about websites. We have websites available for you for this industry at very good prices, already set up and already search engine optimized. So that'll help out. But again, you'll set up the emails. It'll come from Andre at AF Judgment every single email you send out, which means you're basically passing out your business card each time and letting people know this is what you do. And by the way, if you're not doing that in your present business, with a website that is specific for your business and mentions what your business is, you're losing out on a lot of business that you should be getting. So consider that. Okay? So anyways, and finally, in this book, with this book, you get the disc with all of the forms that you're going to need and samples of the forms and so forth. And you get the membership to the forum. That's where you'll be able to go in and you'll be asking questions. And believe me, even after 9 years of doing this, there's always some question I need to ask, and everybody else I know needs to ask. And you have two choices. You can go back and do all the research yourself. And by the way, that's not always easy, because some of the laws will be in the Code of Civil Procedures. The other laws will be in the Code of Civil Code. Some of the other rules may be in the Bankruptcy Code, or in the Family Code, or in the Probate Code, or in the Evidence Code. So there's a lot of different laws that we have to deal with. And having to do all that research, if you enjoy that kind of thing, great. And you do have to do it sometimes. You can't expect everybody to give you everything, all chewed up already. But these two books will get you most of the way there, and hopefully all of the way, until you get the rough ones. Now, let's say you get a big one, and it's rough. They're going to fight you. Okay? Well, at that point, if you're getting 50% as far as your share, maybe it's time to bring in an attorney on your side. Maybe pay them 35% for them to take on the case and fight it. And when it gets collected, you get 15% for passing it along to someone who knows what they're doing and who's got the time to do all the mumbo-jumbo legal stuff that needs to be done. So that's another potential. Okay? As a matter of fact, I know someone right now in Orange County that takes judgments and then does the research, finds the assets, figures out what's the best way of collecting on the money, and then he hands it over to an attorney to actually do all the paperwork. And they've got a business transaction, a business relationship, and they have a built-in percentage and so forth, and that works for them. They're both busy, and they both make money. So obviously, you want to try to do everything as much as possible yourself, because that way you keep more of your money, and you need less business to make good money. I have to say that in 9 years of doing this, I have had to hire an attorney twice. Every other case I've taken, I've done myself without attorney's help. And again, I started with absolutely no knowledge, and now I'm writing books and teaching others how to do this. So we will post at the end of this video our website, where you can contact me if you have any questions. And it will also include discount codes for both of these books, so that you don't pay retail ever. Okay? There's no need for it. They have 30-day money-back guarantees, so if you don't like them, just make sure you return them in new condition, and you can have your money back. But once you see them and once you read them, I have to tell you, we have not received one back. By the way, this book here, It is right now in 7 county law libraries in California, and with many more to come because they are ordering them and they are paying for them. They have them now. They have the 2005 version. They are thrilled that it's finally been updated. So this is the book that everybody's using to figure out what to do and how to do it. And we've made it much, much easier than the 2005 version. And you'll enjoy it. I think you'll like what you read. So anyways, that is our presentation. I thank you for your time. Again, if you have any questions, please feel free to email me. We don't provide telephone numbers for a reason, and that's because I'm always chasing somebody or I'm in court. So we don't want people calling in, oh, it's always busy, or oh, I'm always having to leave a message. There is no messages. You need to email me and I will try to get back to you within 24 hours. Okay? Unless it's a weekend or I'm on vacation. One of those few times that I am. But anyways, thank you so much for your time. I greatly appreciate it. And I hope that this has given you some ideas on how you can expand your existing business, maybe go into a brand new business, but make more money this coming year. Okay? Thank you very much.